Hi everyone, welcome to Immigration Talk Show. I'm Rajni Bharara, your host, and welcome back to this amazing show. Well, today, before I move ahead, let me very quickly read out this important disclaimer first. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to this amazing show. Um, Today, we are diving deep into the H-1B visa changes for 2025, and we have none other than immigration litigation attorney Jonathan Wasden, who is here to guide us through it. So, without any further ado, let's welcome John to the show. Hi, John. Welcome back again to Immigration Talk Show. Thank you so much.
Thank you for having me.
Thank you so much, John, for being here. And this is a very important and a very timely topic because people are really confused about, and people really want to know what's happening with H-1B visas because some days, the eminent political figures and the important people are supporting them, and then they are going against it. So people are really confused about, what's actually happening. And are they in favor of H-1B visa, or are they not in favor of H-1B visa? And is the H-1B visa really secure, or what's going to happen? So a lot of questions there, which we are going to deal with today. John, let's directly, start the show. And because I have so many questions to ask from you. So my very first question, John, but before I ask you this question, I would like to tell our viewers that one of the big changes this year is that, jobs actually need to really match the degree someone has. And, it's not enough to be close anymore. It's been described as direct relationships. So, John, if you can tell our viewers that how do employers make sure that their job descriptions are spot on to, avoid getting rejected?
So there's really two different categories of employers and two different burdens that you've got to establish depending on what type of company you're going to work for. If you're going to work for a direct product company, say like an Apple or somebody like that, it's typically very easy to establish the degree requirement. You have to just put the specialty occupation code, and the Department of Labor connects that code up with the type of degree, typically computer science, and that usually will not get a whole lot of questions asked. The second category of employers are the staffing consulting companies. There is where we see all of the scrutiny on degree requirements, and it's tied into another requirement which has been resurrected in the new regulation that's come out, which is attempting to force employers to show that they have a specific work project for the employee at the time of filing the petition. And that's a project with a third party, placement type situation. So in those cases, for those employers, what we're seeing is USCIS is pushing for involvement from the end client and having them endorse or provide information, information about the degree that's required for the project.
Okay, thank you so much for answering the question, John. I would also like to know from you that if someone requires a specific job and they have like a specific degree, but they are not completely related, but like closely related with the relevant experience. So would that still be considered a valid match under the new rules?
One second. My apologies. Yeah, so the closely related thing is going to be driven by a couple of different factors. And again, if the Department of Labor says that the job that you're doing, the specialty occupation or the standard occupational code requires a degree in that specific specialty, then that should really satisfy it. Now, the question is going to be for staffing companies, the project that you're working on, they're asking for details about that project to show whether or not it degree matches up with the project you're going to be working on. In reality, the vast majority, if not all, are going to be the same. They're all going to be requiring a degree in computer science or equivalent. And most of these things, I don't think the degree requirement is going to be the issue. I think where the issue is going to come in is the involvement of the third party or the client and them endorsing the petition basically, or providing their requirements for that contract.
Okay. Okay. And what if a company is hiring for a brand new role, where there isn't a perfect existing job description to follow? So how should they approach crafting that description?
So I guess it would really depend on what they're hiring
Okay.
for. As a general rule, hybrid positions do get a little bit more scrutiny, right? Quite a bit more scrutiny, depending on what the hybrid is. It's historically been the kiss of death to have any type of requirement for business administration in an H-1B. So I would say any type of hybrid that requires, a business administration is probably going to be a tough sell. But, if you're talking about, other types of hybrids where it's equally technical, those I think are pretty easy to craft the job description and fit into an SOC code. Just it takes a little bit of work and analysis and some documentation, but I don't think that's going to be a huge insurmountable burden for people to make.
Okay. Okay. Thank you so much for answering the question, John. And to our viewers, I would like to say that we are live on Immigration Talk Show. And if you have any question regarding the topic, related to H-1B, you can also give us a call on the number 425-436-6335, and you can put the access code 988888. Yes. So dial this number, put the access code, and you'll be able to ask your question directly from John on the show. So any question related to H-1B, please dial the number. So John, coming back to you, I would also like to ask that, USCIS is saying that for extension, they'll usually approve them unless something big has changed, right? So I would like to know that what counts as major change. People are a bit confused about what could cause problems. So if you can please explain our viewers that what exactly is major change, in either the job or the company that could cause an H-1B extension to be denied under this new policy?
Yeah, so all things staying the same, USCIS is allegedly going to defer to the prior adjudication that approved the petition if nothing's changed. Again, but what they're really getting at is a project-centric analysis. So if you've been working on a project with client A, and then for the new petition, you're going to be switching to client B. That's not going to be getting any type of deference or respect from USCIS to the prior decision, because it's a new project and they'll analyze that particular project.
Okay. Okay. And let's say if a company maybe is acquired by another entity, does that also always necessitate the new H-1B application for existing employees, or are there exceptions?
So that there may be some RFEs, showing connecting the dots of ownership, especially if the acquisition was done, mid visa petition, like halfway through your 3-year stint. They'll want to make sure that the employee maintains status and they were working for the right employer all along. And so the maintenance of status issue may come up, and you'll just have to provide that documentation about the transition of ownership. That shouldn't really be a huge concern, but in terms of deference to the prior decision, if you're working on the same contract, you show that it's the same ownership situation as before, just a new owner has stepped into the same corporate structure. It shouldn't be a problem. You should be eligible for deference as long as the project hasn't changed.
Okay. Okay. John, this is one question which I, usually get a lot from people. So they also want to know that, let's say, if the employee receives a significant raise, that reflects the market value. So also, is that considered a major change that could, impact the extension?
that is one of the trickier things to deal with, because the Department of Labor and USCIS have differing views on what constitutes a major change, especially in the wage area. USCIS doesn't comprehend how wages work in the private sector, and so you're going to draw some scrutiny if you have evidence of bonuses that really are disproportionate to the prevailing wage that's listed on the petition. Now, typically, their USCIS is not going to have access to what you're actually getting paid unless you give it to them. And the place where that happens typically is in the site visit. And the important thing for employers to know and for employees to know is during the site visit, two things. One is you have the right to a lawyer to handle that process. The other is your lawyer really shouldn't be giving evidence of pay to USCIS, because pay evidence is something that is by statute given to the Department of Labor exclusively. And USCIS has no oversight or no statutory authority to manage the wage requirement in a particular case. So if you give them that information, you're just asking for trouble. So my take is, when I represent people in site visits, is I push back on any type of request for wages just to avoid the problem. Because quite frankly, I just don't trust USCIS, especially FDNS, the people doing the site visits, to comprehend how the real world works and understand how business works. So I just don't want to complicate the situation at all.
Okay. Thank you so much, John, for those insightful answers. I see a lot of people joining us and are also posting their questions in the comment section, which I'm going to take in a bit. But before I do that, I also want to talk about, these worksite inspections. So, John, we are hearing that there will be more worksite inspections to prevent fraud, right? So it sounds like the employers need to be prepared. And if you can talk about, what are the key things they should have ready?
Yeah. So, the first thing there is they say it's to prevent fraud, but USCIS's definition of fraud doesn't really match up with the legal description of fraud. And again, in their mind, they're trying to make sure that the project that you're working on is the same project as when you had the petition filed initially. That's something that we're in the process of preparing to challenge in court. That's an aspect of the new rule that we're litigating. We've won this issue once before, back in 2020, and we got this project-centric analysis rejected and kicked out of court. I don't see the end result being any different in the next case that we file. So until that court rules on it, though, we're stuck with USCIS's reg. And fraud is overtly going out and providing false information on an immigration application to get your visa. But switching employers is something that the law allows. That there's no fraud in switching contracts or switching projects, not employers. So focusing on where you're working is not something that's fraud. And they misconstrue that and they screw that up all the time. So again, that's why it's important for these site visits that you take advantage of your right to counsel. There's a law called the Administrative Procedure Act, and it's if anybody's writing it down, 5 USC 555. And that's what gives you the right to counsel in administrative proceedings like this. And your lawyer is going to know what the problem areas are. Your lawyer is going to know what they're actually looking for and how they're going to use it, and is going to be best situated to protect you and shield you from invasive, unreasonable questions and demands for document production. And so take advantage of that. I know a lot of people will sit there and say, oh, I haven't done anything wrong, I'll just give them everything they ask for. Those are the people that end up getting visas revoked and get fraud findings, because USCIS will take information that you give them that you have no idea that there's any problem with, and they will flip it and use it against you And that could be the end of your future in the US because some, high school educated FDNS officer misunderstands what's going on. So you just really want to be careful. And if your employer hasn't retained somebody for the site visit process for the company, I would say just, it's probably worth retaining your own person just for that site visit, just to protect you, because it's a relatively cheap expense considering what's at stake. So I would just make sure that you don't give in, you stick to your guns, you tell them to talk to your attorney at every turn, no matter how hard they nag you, no matter how hard they try to manipulate you. Just keep bringing it back around to talk to my attorney, he'll schedule everything. And don't interact with them directly.
Okay. So should they like hand over the documents to them, or should they tell them that talk to the attorney and
Yeah, the only document they should turn over is a G-28, which is the notice of appearance of counsel. That has the attorney's information. And the only thing they should say to the officer is, here's my G-28, contact my attorney, or I'll get my attorney's information to you, or my attorney will reach out to you. Everything should be channeled through the attorney. A very simple reason. If you say something or provide documents to FDNS and USCIS, then they can flip that around and use it as a fraud basis of a fraud finding against you. If I say something as an attorney, they can't really flip it against you so easily. And so, you buy yourself a little bit of protection and insulation. These site visits are getting far more frequent and far more aggressive than they've ever been before, in large part because they have, hired so many of these FDNS investigators, for lack of a better word. I think they're over 2,000 now, and just 4 or 5 years ago they were around 800. So they've really expanded their reach and scope, and they're bored with nothing to do other than harass people. And these are not the open-minded type of people that you would like to have working in government. They are all on board with Stephen Miller and Trump, and they are not to be trusted.
Okay. And John, this is also one of the important questions that we get from a lot of our viewers. Sometimes they're worried about losing the original document, right? So they also ask that can they keep the copy of the document with them if they get these visits, or do they really need to have the original document with them?
So for the G-28, the G-28 can just be electronic. Anymore, everything, you should take a digital copy of everything with you anywhere you go anymore. It's easy to do. You've got the cloud. So I would have all of your documents organized electronically. If you want to hold on to the hard copies, fine. But I would think electronic copies should be fine as a general rule.
Okay. And John, also, are there specific red flags that these immigration officials are likely to look for during these employee interviews?
So it's interesting because they will just get hooked on something that is incredibly inconsequential and you wouldn't in a million years think would be a problem, and they will twist it into a problem. We see this a lot, especially at the port of entry with CBP, but we've also seen it with FDNS, where somehow they get access to your email, like you give them your phone or you give them access to your email account, and they'll see that somebody emailed you a draft resume that you used as a template when you created your resume. Everybody who's ever made an initial resume, especially early on in their career, has borrowed somebody else's resume for formatting to make sure they're doing it right. I did, many times. What USCIS and CBP are doing, however, is they're saying, oh, you're using somebody else's resume. That's fraud. You're inadmissible. It's a fraud finding. Absolutely bonkers, absolutely crazy. Doesn't meet the legal definition for a fraud finding, but that's how far they're going and how far they're reaching to mess with people. And so you just really need to protect yourself and advocate for yourself and, set up some firm boundaries so you don't give them the opportunity to mess with your life like that.
Absolutely, absolutely. And John, do you think, are there like some specific industries or maybe some sectors or company sizes that are more likely to be targeted for these worksite inspections?
Yeah, I think the consulting staffing industries are the ones where all this focus is being placed. There is a smaller degree of attention given to EB5, and that's a kind of a minimal role for FDNS, but most of it is looking at F1 OPT issues and H-1B issues. That's where the vast majority of their time is spent. And it's all, for those cases, it's almost all within the staffing and consulting industries for IT.
Okay. Okay, thank you for answering the question, John. Let me quickly say hi to RK. Hi, RK. I see your questions, and I'm going to take those and ask from John. And hi, Bhaveen, Rahul, and Trisha. I'm very quickly going to take your questions. Please stay there. Let me, finish a few of my questions, and then I'm completely going to move to your questions. John, I would like to talk about the H-1B lottery also for a bit. So the H-1B lottery now, not only focuses on individual applicants, focuses on individual applicants and not just applications, right? So how does this new process change the odds and how can people improve their chances?
So there's really no way to improve chances for an individual applicant any longer, because it doesn't matter how many companies register your name, you only go into the lottery once. So it's when they came out with the lottery the first time around, immigration lawyers looked at the process that they were suggesting and said, this is going to be a massive mess. You're going to have, companies filing a whole bunch of duplicative registrations, and it's going to skew the odds in their favor. And USCIS, again, in their infinite wisdom, said they weren't concerned about that. And they would fix that problem by making employers certify that they would, file a petition if they were selected in the lottery. And, we all know what happened. They look like fools for, creating a lottery system that was so flawed. And so then they started lashing out at individuals and companies that got H-1Bs for multiple registration filings. But in the new system, the new system is what a lot of people had recommended they do in the first place. And there's really no way to game that system. You go into the lottery once, it's in the random, and you get selected or you don't. And there's really no way to up your odds.
So then there is a downside to having multiple employers, submit registrations on behalf of the same candidate.
No downside, but there's no upside either. So, your name only goes in one time, regardless of how many job offers you have. So there's really no benefit or harm to having multiple jobs.
But then will this be considered, or maybe do you think it is going to reduce the chances? Because then, they might think that this person has applied a lot of times, or not the person, but has a lot of employers who have filed on his behalf. So will they consider this as maybe gaming the system? Because you never know. I mean, these days, anything is happening, right? So just curious to know.
Yeah, no, I don't think they'll consider that gaming the system, just because, again, gaming the system means that you're increasing your odds of selection, and there's no way to increase your odds of selection in the current system because your name goes in once. So the number of job offers you have is pretty irrelevant to where you may see them digging is in the petition process. If you have a whole bunch of different job offers, they may question if those were bona fide job offers. But as long as the petition that you're getting hired for is a bona fide job offer and they can establish that, I don't think it'll be a problem that you got a bunch of others.
Okay. Okay. And also, are there specific maybe degree levels or fields of study that are currently seeing the higher chances of selection?
You have the master's draft, master's lottery, and you have the bachelor's lottery. And again, there's really no way to game the system. So your odds are the same if you have a master's or higher, a qualifying master's or higher. And if you're in the bachelor's group, everybody has the same odds. So I don't think there's really any secret sauce that you can come up with to increase your chances of selection.
Okay, and what about the smaller companies? Because they often feel that maybe the larger companies have more chances. So do you think that the smaller companies have a disadvantage under this new system compared to the larger corporations that can afford to submit maybe more registrations?
Potentially, because if you have multiple employees that you're putting in, you would have more bites at the apple for those employees. But when it comes down to it in the adjudication process, if you're selected, you're still going to have to show that you have the bona fide job offer. And that's where, the abundance of job offers to people, either from the company side or abundance of job offers for the individual, isn't going to help you. If you're applying for 1,000 employees, it's highly unlikely that you're going to have 1,000 bona fide job offers. And so that's going to draw scrutiny. So I think it'll all even itself out, but I don't think that'll hurt or help in the selection process.
Okay, okay. Thank you so much, John, for answering those questions. Now, I would like to also talk about the I-129 form. So, there's a new version of the I-129 form for all petitions, right? So, if you can please, tell our viewers that what do companies need to know about this new form?
So, for the new form, and also the supporting documentation, if you're doing staffing, they're going to want some extra details about the project and the client that you're getting placed at. And, again, this is one of those things that we're litigating, that we're preparing to fight. And if we're successful on this, the next thing we challenge is the form and have them change the form, because if the form is asking for things that, isn't supported by the outcome of the lawsuit, then the form needs to change. But for right now, the focus is going to be on the project and establishing whether or not you have a project. We're also seeing a return to a policy that was kicked out in court back in 2020, which is the short approval process. So you'll request the validity period on the petition, but if you don't have documentation to support a project for that entire duration, they're shortening it again. And so that's something that you're going to have to contend with, is do you have documentation to show that that project is going to last for the duration of the requested validity period?
Okay. So are there any particular sections of the new form that are causing maybe confusion or errors for applicants?
So not right now. I think most lawyers that are handling this are seamlessly transitioning to the new form. I'm not terribly concerned about the form per se as so much as I am concerned with the substantive requirements and the regulation that are driving changes to the form. And those are things we're just going to have to fight out in court. I think we'll be successful in the short-term approval issue. I don't think they can do that legally. And I think we'll be successful on their invalidating their project-centric requirement. But until we get there, USCIS isn't going to change until the court tells them to stop.
Okay. Also, but John, do you think that will there be any potential consequences maybe, or even if the applicants make even the minor errors or inconsistencies on the I-129 form?
So inconsistencies are always going to be a red flag. Okay. And so, for the employee, you just want to make sure that everything that you submit to your employer is as accurate as it can possibly be. And you just want to make sure that there's nothing in your work history that you're using to support your qualifications that has any problems. And it may be worth, talking to your own counsel, your own attorney, if you suspect there might be a problem, just to make sure that all your ducks are in a row and everything checks out. Your employer is hiring the attorney to file the petition, and you can't pay for that. Like in the rules, you're not allowed to pay for that for good reason, which means that they don't really represent you. They represent the employer, and they have the employer's interest at heart. So if you're concerned about a problem in your immigration history and how to deal with that and how to address it, it's best to get your own independent analysis of the situation by an attorney that actually works for you. And your attorney that works for you can talk with the employer's attorney, and that you can come up with a strategy that's best for your situation. But just don't get tricked into thinking that just because there's an attorney working the case for their employer, that they're worried about you. They're worried about the employer.
Okay. Well, thank you so much for answering these questions, John. Let me now quickly move on to our viewers' questions, because I'm sure they've been waiting to get an answer from you. So let me quickly take RK's question first. RK, he's here, and he says, do you see the new administration trying to change the H-1B regulations? What do you have to say? Because they are mostly trying to change everything.
So here's the dirty little secret. As a general rule, and this was definitely true in the Biden administration, the political level, the people appointed by the president and confirmed by Congress, those people had very, very little impact, if any, on the direction USCIS headed. USCIS has been heading in the same basic trajectory for 20 years. And it's all the senior executive civil service people that are driving that. And they have been 100% on board with Trump from Trump's first administration. And in fact, the regulation that they created was pretty much everything that the Trump administration tried to do in its first term. And it got finalized under the Biden administration. It was basically a Trump regulation that Biden's team signed off on. But the people that were really driving that policy and doing that work were the career civil service executives. And they don't change with the administration. But they are completely on board with Team Trump. And I don't really see how Trump would make the regulation any worse than it currently is, because it's everything that they wanted on their first go round. So I don't really see them going through the regulatory process to change it, mostly just because it's a very, very long process. It's very difficult. And it's even more difficult when you have a brand new regulation that just came out. So I'm not terribly concerned about seeing any new regulations coming out dealing with the H-1B.
Okay. RK, I hope you have got your answer. He also has one more question. He says, are they allowed to give short or 1 year extensions?
So legally, no. But are they doing it? Yes. Now, they were doing something similar back in 2018, 2019, and we sued them on it and pointed out where in the statute it says that they can't do that. And the court very quickly sided with us and invalidated USCIS's policy. I don't see how we're going to have a different outcome this time around, just because the law hasn't changed, the statute hasn't changed. And so I think ultimately that process will get invalidated again. But until a court rules on it, until the judge bangs the gavel and enters an order, we're going to be stuck with USCIS screwing people over by doing these short-term extensions. So far, I haven't seen anything as crazy as we saw in the first Trump administration, where you'd see one-day approvals where they were mailed out and they were invalid by the time you received it in the mail. That level of insanity hasn't occurred yet, but I wouldn't put it past them to try.
Okay. RK, thank you so much for your questions. I hope you have got your answer. In case you have more, continue posting your follow-ups in the comment section. And meanwhile, let me take other viewers' questions. Rag is also here, and Rag says, okay, I think, Control, if you can please show the question. Okay, what changes can we expect with L1A and blanket L1? It's not related to H1B, but if you would like to answer this, John.
Sure. So we're already seeing problems with the blankets at the consulates. I expect the L1 category in general is just going to get a lot of additional scrutiny that they haven't seen so far. I mean, the dirty little secret is, as much as USCIS hates the H-1B program, they hate the L1 worse. And in their mind, the only people that really are eligible for L1s are massive multinational companies. And smaller IT companies really shouldn't qualify. I expect to see the policies of the consulate and also within USCIS to track their belief on that. And you'll see policies on L1s and adjudication trends on L1s get really, really tight and very difficult.
Okay. Rag, if you have any more questions or follow-ups, please continue posting them in the comment section. But I hope you got your answer. Thank you for your comment and your question. RK is actually back, John, and he says, so this means they will not try to remove the lottery method of selecting H-1B.
No, they won't. They won't take away the lottery. There's really no way other than the lottery to do it, just because they get so many applications in a fiscal year that they have to do the lottery.
But John, don't you think, sometimes, because mostly, especially the current administration, they are always talking about, merit-based selection of the visas, and people should be here in the country on their merit basis, right? And then they have this lottery selection process. Do you think these two align with each other?
Yeah, so I guess the merit filtering would be, do you qualify for the specialty occupation? Do you have the required degree? Do you have the highly specialized body of knowledge? That's where the merit comes in. And if you have a whole bunch of people that have that level of knowledge and that type of degree, how do you pick between them? It would, the lottery is the most efficient way. If they switch to, a weighted process in the lottery where they give different points and weight to different factors, they could do that and change the lottery in that way. I'm skeptical about how effective that would be and how quickly they could get such a regulation through the process. I think that would probably take longer than they have patience for, and it would be harder for them to get worked out in practice. It's because I don't think they understand, the space that well. You don't have people working in USCIS that have, bachelor's or master's in computer science. You don't have people with the degrees, and the experience to even know how to create a weighted system, because they don't understand the industry. So I'm not terribly optimistic that a weighted lottery process would come into play based on merit characteristics.
Okay. Thank you so much again for answering the question, John. Let me quickly take maybe Trisha's question also. Trisha is also here. Trisha says, what are the key changes to the H-1B electronic registration process in 2025, and how can employers ensure they are complying with the new requirements?
So the biggest change is it's no longer an employer-centric process. Obviously, when you have employers, filing a whole bunch of registrations, and each registration goes into the lottery, there was opportunity for some shenanigans, because you can dramatically increase the odds of one person selection by having a whole bunch of different companies filing applications. That's gone now, and so it's pretty easy to comply with the lottery rules at this point. Where The only thing that I have concern about going forward is how far USCIS is going to take this bona fide job offer at the time of filing requirement. That's what we don't know. If they're going to say that you have to have a signed contract at the time you file your registration, that would be an absolute nightmare. It's completely unworkable in reality. But if they took that position, if your job is bona fide only if you have a contract signed at the time of the lottery registration, that's going to be a mess. It's going to cause all kinds of problems for people.
Okay, so Trisha, I hope you've understood everything and you got your answer. Thank you so much for your question. Continue posting your follow-ups. But Rahul, also let me take the questions quickly. Rahul says, I'm in the process of applying for an H-1B visa in 2025, and I've heard there might be changes in how the lottery works. Can you explain what different this year and how it might impact my chances?
Yeah, so again, it's employee centric, right? So an employee can have 20 different job offers, but they only go into the lottery once. Whereas before, if they had 20 different job offers, they could go into the lottery 20 times. And so they would have 20 bites of the apple instead of just one. Now everybody has the same odds. Everybody has that one chance in the lottery. And there's really no way that you can game the system to increase your odds of selection.
Okay. Rahul, thank you for your question. Let me take Bhaveen's question also in the meanwhile. As a current H-1B holder who wants to apply for a green card in the near future, do the 2025 changes to the H-1B process impact my green card application or timeline?
So probably not the application or the timeline. But what I will say is we see USCIS has become very, very aggressive in terms of going through people's histories, especially their initial H-1Bs, right before the adjustment of status interviews. So we see them go through initial H-1Bs looking for any reason that they can invalidate that initial H-1B and take the cap number away. So once they take that cap number away, you have no path for extensions. You'd have to go back into the lottery to stay in the US while you're waiting for your green card. And we see them do that time and time again, where somebody's almost at the finish line, almost at their adjustment of status, and they screw with them by revoking the cap H-1B. And it's almost always, in fact, I've never seen it go another way, based on something the petitioning employer did and not something the individual did. And we're 10 years down the road, and you're not working for that same employer, but you're getting penalized for what that employer did. And so just make sure all of your documents are very, very consistent and squared away. And if you're an H-1B that's working for a staffing company, I would not go to your adjustment of status interview alone. I would take an attorney. And I would take an attorney that's a little more on the aggressive side, just to make sure that they are not just going to roll over and, let USCIS mess with you. So I wouldn't do your application by yourself either. I'd make sure that you have an attorney put eyes on that and really scrub it to make sure that, your 485 is tight and your supporting documentation is tight.
Absolutely. So make sure that you do that. Bhaveen, thank you so much for your question. And who better to deal with USCIS better than John, because John has an experience dealing with them. So make sure that you get in touch with Jonathan Wasden, everyone. You can give him a call on the number 844-592-7336. I would like to repeat the number, 844-592-7336. You can also email him. His email ID is support@wasden.law, support@wasden.law. And you can also visit his website, which is www.wasden.law. So make sure that you get in touch with him. And for your H-1B cases or any immigration-related cases. Now, let me move to another question from another viewer. I think Rag was actually back. So Rag said he had this L1. Okay, he has in this also. He says, with the Dropbox changes, will a third country national consular option be invoked again for L1 and H-1B?
Sorry, say that one
With
again.
Dropbox changes, will a third country national consular option be invoked again for L1 and H-1B?
That I'm not sure. I don't know. I'd have to look into that one, honestly.
Okay, all right. Thank you, John. Let me take maybe ZQ's question. ZQ says, are there going to be ICE raids in schools and offices? Sorry, seeking an attorney's point of view.
So if the schools are complicit, yes, I would say in your red states, it's definitely going to happen. I would not be shocked at all. Keep in mind the way the Trump administration is rolling out their entire immigration enforcement, plan is for maximum attention. I mean, Trump is an attention seeker who has to have people talking about him all the time, and there's no better way to do that than do something incredibly, confrontational, like sending people into churches, schools, offices, and that gets his base really excited because they love the idea of ICE going in and arresting people and kicking out illegal immigrants, and it gets him the news. So it's a win-win for him. So yes, I would say the odds of that happening are incredibly high.
Okay. ZQ, I hope you've got your answer. Let me quickly move on to Empire's question. Empire says, doesn't the administration already have the regulations blueprint how to change the H-1B to a wage base from the last term? I know wage-based H-1B impacts smaller companies, but do you think it's fair? Not fair? I mean, do you think level 1 worker has the same merit as a level 4 worker? What do you have to say, John?
So, really, merit is a question in the eye of the beholder. If you're a small company, or if you're, any company, really, you've got to have people working at every level. You've got to have your entry-level folks that you're developing. You've got to have your senior folks that are kind of more in a advisory management expertise role. And you can't have, the saying is, too many chiefs and not enough Indians. You can't have too many people at the top and not have people at the bottom that you're developing and bringing along. So I think you need a mix in order for the system to work right.
Okay. Empire, I hope you have also got your answer. Thank you so much for your question. We only have 10 minutes. Let me quickly move on to our Facebook questions also, because we have a lot of questions coming from Facebook groups too. So Control, if you can please share your screen and maybe share the Facebook questions. Okay, so we have this question, John, from a viewer or a follower. He says, hello, can I submit the I-539 application online even though I have 2 children applying for F2 status? What do you have to say?
So I'm assuming they're talking about the extension of H4 status. So you can submit that online. If your kids are in college I guess I'm confused about what their primary status is. Are they an F1? I don't know. I need more details on that one. I need to talk to them offline before I can answer that.
Yes. So to this viewer, I would like to say maybe you should directly get in touch with John regarding your case so that he can help you better. And also, like he said, he would need more details regarding your case. So yes, for now, let's move on to our next question. So Saundarya says, hi all, asking for my friend. A friend of mine filed for an H4 extension and received the receipt notice, but the renewal is still pending. Their current EAD is valid until March 1st, 2025. Is there a risk that their I-94 will expire after that date, even though they have the EAD receipt notice? If not, what should they tell their employer to ensure their position is held during this time? Need guidance for what are the options they have with the employee, and has anyone been in this situation? What steps can they take? So John, if you can please guide them.
All right, I'm going to read that. There's a lot going on here. So, I mean, it is a common thing, and I think we're going to see a whole lot more of this, that they will be delaying the H-4, the adjudication of the H-4 extension, which causes a problem for those people that need the extension approved in order to have their EAD extended. The prior Trump administration, the first time around, put the H-4 EAD in their crosshairs, and they were really trying to make it impossible for H-4s to have employment authorization. Same with L-2s. And they were trying to change the regulation to just fully eliminate it. The problem was they couldn't get it through the regulatory process. And so when they weren't able to get it through the regulatory process, they just changed the way they adjudicate the H-4 and the H-4 EAD. They first split up the primary H-1 and the H-4. And then they split up the adjudication of the H-4 extension and the EAD. And so you had a process that used to take a couple of weeks that now is taking, upwards of a year. And they designed the adjudication process in a way to almost guarantee everybody with an H-4 EAD would be without status temporarily and would be without an EAD. And you couldn't apply for your EAD because you didn't have status. I anticipate we're going to see something similar to that again, and we're going to have to go back into court again. The last time when they did this, we ended up suing and getting the process changed. And there's some structural things in the law that we were able to change through litigation, like L2s getting their EADs incident to status, so they don't have to apply for an EAD. But we're probably going to have to be going back into court on behalf of H-4s, because these processing shenanigans that they're going to start doing are really going to mess with people's lives. So everybody in that situation really needs to be aware and needs to start taking some precautionary steps. And if folks want to reach out, we can tell them what they need to be thinking about doing early on to protect themselves.
Okay. All right. Thank you so much for answering the question in so much detail and for that insightful answer. John, let me very quickly take this next question. Navya, hi, I have a question related to document for Dropbox for H-1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, employment verification letter, from the consulting company with whom my H-1B is filed, or the client that I'm working with?
So that's something you'd probably want to have an attorney put eyes on both documents just to make sure, and also on the petition, just to make sure there's nothing that's problematic. But as a general rule, what the consulates are looking for at this point is they're looking for proof that you have a contract you will be working on, that you have a client project. And so probably both of those would be useful to submit, one showing that the employer issued you an offer, and the other showing that the client has a project for you to work on. But again, you want an attorney to look at those to make sure everything matches up and that there's no contradiction or inconsistency. Because if there's any inconsistency in those two letters, that's going to be the kiss of death. And so, talk with an attorney, make sure that you're not doing something that's going to end up hurting yourself.
Okay, all right. Thank you so much again, John, for answering that question. Empire, if you remember, is back, and he says if they aren't going to increase the cap, it's the next best thing is to try to give as much of the small 85K H-1B to level 4. What do you have to say about this?
That's a policy decision. That's what they pay the people at the top of the government to figure out. And if they want to do it that way, that's fine. We can work with that. But, what is the best way to implement policy? I don't think anybody in the Trump administration is listening to me on that one. So my opinion probably doesn't matter much on that issue.
Okay. All right. So, Empire, I hope you have got your answer. Well, thank you so much, John, for being here again. Those were our questions and answers. And thank you so much. It was an insightful episode. I still have a lot of questions pending. But then I would like to do a part 2 of this and would like to ask those pending questions maybe in the second episode. And we can get into more detail about the H-1B and the changes that are going to happen in to H-1B in 2025, and we can take more questions because I still have a lot of pending Facebook questions too. So how about we do another episode on H-1B and take the pending questions in that episode?
That sounds great.
Perfect. Thank you so much again. And to our viewers, I would like to say that to get in touch with John, make sure that you give him a call on the number 844-592-7336. I would like to repeat again, 844-592-7336. You can email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. Well, thank you so much again, John, for being here. It was great having you. And looking forward to seeing you very soon in another H-1B episode.
Thank you, Rajni. It's good to be with you.
Thank you so much. And to our viewers, thank you so much for posting your questions. Thank you so much for being here. And I would also like to tell you that we recently launched, not recently, but today we launched our website, imisupport.com. So make sure that you also check out our website, imisupport.com. And if you have any questions, you can also reach out to me. My number is 732-707-9151. But for now, I'll have to take your leave and we'll be meeting very soon. But for now, like I said, I have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. For now, take care, bye, and keep subscribing and keep watching Immigration Talk Show.